Mr. Bledsoe, let me make something perfectly clear to you. I will do everything in my power to protect my public at all costs. And I don't care if I have to make your bond $2 million. I'm going to do everything in my power to protect my public.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred to determine,
He's leaving.
He's
leaving, right? It's like, here, let me come and mess with you more.
That would only,
right? So it's like adding fuel to a fire.
But they would still have grounds to investigate.
I think is 12 yards per the officer.
So I see that on 10/17 of 24, he picks up a felony assault. And 3 days later, he picks up a terroristic threat. And then he picks up an evading arrest. And they give him PR bonds on these cases. Is that what happened? And
he bonded out since his last setting. I didn't check to see if they were PRs or not, Judge. I know that he had to pay money in felony court.
Yeah, it's just, I'm not done with PR bonds on this. I mean, he picks up 2 new cases if it's the same. Well, hold on a second. Let's not get ahead of ourselves. You've now picked up 2 new cases. You picked up a terroristic threat. You picked up an evading arrest.
I will say our cases are the new cases. So I wouldn't call them new. They're just cases. Well, he picked up the felony, and then afterwards he picked up these 2 misdemeanors.
I don't understand why he's coming here in December when he got a bond in October. How on earth is it?
He was in custody, I think, on the felony.
Oh, I see. Okay, and then he bonded out of the, right, okay.
Yeah.
Got it. All right. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please, what happened?
On October 19, 2024, officers were dispatched to a minor crash at a residential home in Harris County, Texas. The call described a male at the location crashing his motor vehicle, then pulling a gun, and was trying to fight people at the location. When officers arrived at the location.
Welcome back, everyone. In today's video, from what I can see, the case will depend on whether the defense can successfully refute the allegations made against the defendant. If the defense can demonstrate that the incident has been misrepresented, witness statements are inconsistent, or the police did not act lawfully, the course of the case may change. The judge may impose stricter bail conditions considering the defendant's history and the new charges.
Location. They observed people at the location pointing at the defendant. Upon contact with the defendant, the officers introduced themselves as Houston police and told them to stop. The defendant then walked into his residence and came back out approximately 2 minutes later. The officers instructed the defendant to come towards them, but the defendant began to evade on foot from the officer the second time. The defendant ran approximately 12 yards from the officer before placing him in handcuffs. A person search on the defendant revealed he had a prior arrest and an active felony warrant. Upon contact with the complainant advised the defendant was driving up and down the street in his car and crashed. The complainant stated the defendant began to tell the complainant he was going to shoot him and kill him. The complainant advised the defendant then began to reach into his waistband and kept saying he was going to shoot him. The complainant feared for his life and felt threatened by the defendant's statement.
I will say gun was never found. No charges where the gun were ever filed. They charged him with terroristic threat. They would have charged him with ag assault if the police had believed that a firearm was used.
Mr. Bledsoe, let me make something perfectly clear to you. I will do everything in my power to protect my public at all costs. And I don't care if I have to make your bond $2 million. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes,
I don't care who you are. I don't care where you come from. I don't care what, nothing. I want my county safe. You will be signing an affidavit with me today, promising me that you're not going to have any weapons whatsoever. And if I find that you have a weapon, I can have a contempt hearing. You're looking at 180 days in jail every time if you're caught with a gun. Do you understand? I'm sending you now for a drug test. I want to know what, if anything, is going to be in your system as well. I'm ordering you not to use alcohol or illegal drugs, and I'm going to test you like crazy. Do you understand?
Yes, sir.
What do you do for a living?
I work for Leland Airmark Bakery.
Okay, that's what you need to concentrate on. Working a lot so that your time is occupied. When you have too much time on your hands, you become self-destructive. Do you understand?
Yes, sir.
Do
You're right
you
about
have, thank you. Do you have a Texas driver license?
that.
It's a yes or it's a no. Then you're not allowed to drive. On this affidavit, you will also be promising me that you're not going to drive. Do you?
Do you have a different state's driver's license?
City?
He asked if you have a Texas driver's license. Do you have a driver's license from any other state?
No, I'm from Houston.
Okay, sorry. I'm just making sure you didn't have Louisiana or something.
Not drive. I am also putting on this affidavit that you're not going to drive. Do you understand?
Yes, sir.
You're looking around, you're just, heed this warning, Mr. Bledsoe. Do you understand?
Yes, sir. Yes, sir. I totally understand. I only have one off day. I just sleep all day.
Did I hear him say that he had an objection?
No, most
He was,
definitely not.
he was just
No.
asking me a question.
Okay,
No
just
objections.
don't use. Stay out of trouble. You're in enough hot water as it is. You know, the thing is, Mr. Bledsoe, is that a lot of people make very, very poor choices when they're out there in life. And sometimes that choice makes it to where you will live the next 40 years in a 6x9 box. And I'm going to tell you now, I've read have you been to prison before?
Nope.
I've read, I want you to hear me. I've read stuff about what happens in prisons, and it had me in tears. It was as bad as could possibly, if you think of your worst nightmare, it's worse in our Texas prisons. They don't give a rat's behind about you, and you will be passed around like a proverbial doll. It's awful. Believe me, it's not worth it. Don't have a gun.
Yes, sir.
All right?
Thank you, Judge. If I can, Judge, I don't believe there has been actually any evidence presented to warrant
Hold
upon
on, Stephen.
revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge.
Don't
There was
speak.
no like threat of like harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting anyone in danger, threatening danger, anything of that sort.
This is
You
where I will.
have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Sir.
Take a seat.
Thank you, Judge. Back to your point. Do you have a preference on the reset date, Judge?
Tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay.
This is where I will add that the court added bond conditions yesterday, so he had the magistrate.
understand.
Okay.
He did have
So-
these magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did have
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, BLED.
Oh, no. He's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I'll also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry, you're right. You said.
And I'll test.
Hi, good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge, does he need to be brought out, or do you, I don't know your process.
Mr. Jones, please. Yeah. It's only fair, right? Because it's his case,
You
so
didn't hear me.
it's only fair because it's his case, so we might as well bring it up.
No. He asked me to do this, and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
Okay.
That's my client.
He must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
At this stage, the defense is working to both protect the defendant's rights and persuade the court. If the defendant passes the next test, they may be released but placed under strict supervision. However, if they test positive again, their bail could be revoked and they may remain in custody. The defense needs to provide the court with more information about the defendant's situation in an effort to influence the proceedings.
You said Jones, right? Michael
Yes,
Jones?
Judge. Michael Jones, 2546980.
Hold on, before you leave, there's an attorney that's in the waiting room.
Okay. Ms. Beck?
Who?
Is it Celine Beck?
Yes, Judge.
Okay. Oh, yeah. I haven't seen her in a long time.
In the queue.
Good morning. How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No?
Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and They said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse. And then
Right, but then cops get up there.
and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, hey, I'm the police. You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving.
Right.
Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes. Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving. Right? It's like, here, let me come and mess with you more.
That would only.
Right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
The defendant was released on the grounds of being not guilty. If the police department appeals this decision, the prosecution may file a new indictment. However, this is unlikely since the judge has already stated that there is insufficient evidence. Overall, the defense presented strong arguments, and the judge acknowledged that there was not enough evidence to prove the defendant's guilt. I am waiting for your opinions about this case in the comments. To support my channel, like the video and subscribe to the channel.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
Thank you. Hear what happened?